Okay, well, hello everyone. My name's Jonathan. I'm one of the employment lawyers here at KMB, and we're very happy to have you here and listen in on some of the conversations that we have amongst our employment law team here at KMB. So let me introduce you to our team. We have Alex and Rosalie. Guys, do you want to introduce yourselves?
Sure. I'm Alex. I'm part of the employment team here at KMB. I concentrate a lot on litigation, but I help our clients with all sorts of employment matters. And it's fun, challenging for employers, but fun for us to come up with solutions during these challenging and strange times.
Right, thank you.
Hi, I'm Rosalie, and I'm also, of course, a member of the Employment and Labor Group, and I handle, I would say, mostly the day-to-day, issues and concerns at the workplace, but also, of course, litigation matters. And lately, of course, our entire department's been really focused on dealing with COVID and the impact on the workplace, and that's sort of why we wanted to give this webinar today.
Right, and as I said, my name's Jonathan, and I'm the lead in the department. And we help employers with all different types of employment law matters. Of course, there's hirings and firings and employment contracts and really everything in between that, human rights and accommodation and workplace investigations and the day-to-day concerns, vacation pay and discipline and hiring, as I mentioned. And of course, what we're helping a lot of employers right now with is dealing with the pandemic and first of all, dealing with the initial how-to and how to manage your team during the initial stages. And now, of course, we have an eye to recovery. And so I wanted to take a little bit of time and speak with the team. Of course, we're here at our offices and we are all self-isolating in our own offices. And wanted to just talk about a few issues with the team for the benefit of whoever's listening so that we can hit some highlights on what is going on in employment law and what is on the pulse for employers right now. So we're going to talk about a few issues. We're going to talk about, terminations during a pandemic, health and safety matters, layoffs, recalls, leaves of absences, work refusals. We're going to touch upon a lot of different things. And of course, at any time, if you would like to get a hold of us and if you have more questions specific to your business or your operation, feel free to give us a call. Our website is kmblaw.com. And all of our information is available there for you to reach us and get a hold of us. So the first thing I wanted to talk about with the team, Alex and I were talking, we talk a lot about with employers about all different types of issues, but one of the first ones was about terminations during a pandemic. So yeah. Alex, what have you found is happening in terms of an employer who wishes to terminate someone during this pandemic?
Well, we've had inquiries about it, of course, and people are terminating for different reasons. Sometimes it's business necessity, particularly since business is down. They were thinking of dismissing an employee for a while anyway, and they see now when they need to downsize for financial reasons as a good opportunity to do so. I've been quite cautious in the advice that I've been giving our clients in that regard. I think it's a little, well, actually not a little, but considerably more risky to dismiss an employee during the duration of this pandemic. And the reason for that is that unless you have a bulletproof contract that specifies what termination the employee is entitled to, and it's written in a proper way, and often that requires an analysis. So even if it appears that you have a good termination clause in your contract, it may not be as good as one thinks. So it's important to have that reviewed by a lawyer. But traditionally, unless there's that bulletproof termination clause that limits an employee's entitlement upon termination, they're entitled to what's called common law reasonable notice of termination. And it's dependent on a number of factors. The nature of the employee's position, how long the employee has been employed with you, the employee's age, and also the availability of similar employment.
That's right.
Having regard to the experience, training, etc. of the employee. Now, that availability of similar employment, I think, is going to be accorded more weight. And I have to say that I'm speculating. I'm looking in the crystal ball a little bit right now, because the courts are actually, while litigation is active, we're still negotiating files and things like that. In terms of pushing things through and getting hearings and decisions out of the court, that's pretty much on pause right now. There's no hearings happening. Limitation periods have been suspended. Procedural deadlines have been suspended for court matters, at least.
Wait, so does that mean I don't have to pay any of my bills? No. What's so important about a limitation period?
No, that doesn't mean that. The courts will reopen one day, and
Right.
and bills will need to get paid, or else. But yes, so the concern is that one factor, the availability of similar employment. I think that's going to take more precedence now. I think the courts are going to look at that, accord that more weight than they would usually.
Mhm.
And unfortunately, as a result of this pandemic, in most industry sectors, the availability of similar employment is less now than it was pre-COVID-19.
Right.
So what does that mean? That means that employees are likely going to be entitled to more notice than they otherwise would be, which is why you need to be careful in terms of drafting the termination letter and what you set out, and why you should probably get legal advice before you do anything drastic. Because the flip side of this also is an employee is required to mitigate their damages. And I think that this is going to also be affected by COVID-19. Now, what mitigating their damages essentially means, once the employee loses their job, they can't just sit and wait on a court judgment or settlement. They're expected to be out there and making reasonable efforts to find suitable replacement employment to replace that income that they've lost by virtue of being terminated. I think the standard for what reasonable efforts are during this pandemic, and the likelihood that an employee will successfully mitigate, that is, get a replacement job during this time, is low. Mm-hmm. So that doesn't bode well for employers either, when it comes to assessing their liability, how much they're going to have to potentially pay out in the end. So I think those are things that employers need to be mindful of. And if they are forced, and I know sometimes employers feel forced, that circumstances dictate that an employee must go, at least get it checked by a lawyer. Mm-hmm. I'm often asked, in fact, I was asked not long ago, well, I'm suffering too as a result of this pandemic.
Yeah.
I have business losses. Doesn't that cut in my favor? And the honest answer, when it comes time to assessing the entitlement of an employee upon termination, is no, it doesn't, or traditionally it hasn't in the pre-COVID-19 era. The employer's financial difficulties are not supposed to form part of that analysis. Is it possible that it could change as a result? Yes, it's possible. But right now, I'm trying to assess risk based on the law that it is today, because even though this is an extraordinary event, when it comes time to risk assessment, you should always be cautious in projecting a swing in the court's direction.
Yeah, and there are a lot of different ways that the law has to catch up to what is currently happening, and even for some of the employment laws that were recently updated and some other laws that were passed, some governments have retroactively change the law. They set the date when certain changes can be made or certain things come into effect retroactively. But that's extremely rare. Normally, lawyers and society in general have months and months of time before a law is enacted. So for a law to be, or a rule or a new clause added into a law, for it to be added in and applied retroactively is extremely unique. So it's like you said, it is currently, there's a lot of unknowns with how a termination during a pandemic is going to be treated by the courts. I think that there's strong arguments on both sides. If an employer has absolutely no recourse, then the only thing they could do is to terminate someone. They had no other choice based on a financial impact on the company. There may be a sympathetic judge that says, well, maybe you don't have to pay as much notice to that employee. There might be a judge that says it doesn't matter, the financial difficulties, and there have been cases that say that. So there are a lot of unknowns, but some of the best advice that I know I've heard employers tell me, and I tell other employers before the pandemic, was to hire slow and fire fast. But because of this pandemic, I haven't been saying it that frequently, because I think employers should be very cautious to completely terminate, for cause, without cause, any employee during a pandemic until, in my opinion, until at least the emergency is lifted.
I would even extend that to layoffs, potentially, temporary layoffs. So the Employment Standards Act provides an employer the ability to temporarily lay off an employee, not without it being a termination. However, in the pre-COVID-19 era, the law was that you have to be careful in doing that. If it's not a matter of industry practice for frequent layoffs, or if it's not specified that you can lay off an employee explicitly in their employment contract, the employer runs the risk of that temporary layoff being a constructive dismissal, which is not the same as firing in substance or in fact, because you're not firing the employee, but the legal effect is the same. It's as if you've dismissed the employee because you've changed, you've laid them off and they're contracted and provide for a layoff. So
at what point, Alex, does an employer have to worry whether the layoff turns into a termination?
I think the time to worry about it is before, if possible, you lay off the employee. Go get advice. Go have a lawyer review the employment contract to see what it says about layoffs. Understand your industry to determine whether it is a common industry practice. And if neither of those things apply, seek to manage the risk. Now, I keep saying this is the pre-COVID-19 era. This is, again, peering into the crystal ball. I think this is another area of law that may see a shift, a gradual shift. All it takes is a few judges who are going to be, and once the courts reopen, they're going to be backlogged, and there's going to be tons of claims in this respect and decisions that are coming out. But I think our law is adaptable. Some people say it's slow to change, but I think there will be a recognition of the reality of the facts on a number. Oh, the light went out.
Our lights are on timers, so unless you move around, the lights turn off. We're very energy efficient around here.
We are. I was worried that the power went out, that the pandemic got
so what you're saying is layoffs, you should be concerned about the effect of a layoff even before you lay off. But Alex, right. and it's uncertain, we're going on the laws.
That's right.
Before the COVID. But there are going to be employers who are watching this saying, I had no choice. There is no work for the employees to do, and I had to lay off.
Absolutely. Well, if that's the case, still, if you've already laid them off, probably not, should have consulted the lawyer beforehand, but consult us. Let us try to manage that risk. We recognize that there's the reality that a lot of employers simply don't have work for their employees, or maybe they're not an essential business and they were required to close. That brings in, like, there's an argument that the contract has been frustrated, right? That the whole employment relationship has been frustrated. It's impossible in the circumstances for the employee to work for the employer. So what happens then? So that's another thing that the courts are going to have to grapple with. But I do, it's dangerous to predict, but I'm going to predict anyway. I predict that the courts may, given that such a significant percentage of employees right now are temporarily laid off, that the old rules about it having to be specifically set out in their contract or industry practice or a reasonable expectation of the layoff, those might be relaxed over time to recognize.
Yeah, I agree. And actually, how I would add on to that is, we're in kind of the middle part of May right now, talking today.
True.
I suspect that the provincial government will update, in Ontario, will update the rules around layoff. Other provinces have done it. The federal government has done it for federally regulated employees. And it's different depending on what jurisdiction you're in. But for Ontario, they haven't touched it yet. So what I think employers should know is this. Number one, the Employment Standards Act permits you to lay off an employee, but the employee has to agree to that layoff beforehand. If they don't, you run the risk that it could be considered a constructive dismissal. Right. If you've already laid off your employee, there are a couple things you should know. Number one, a short layoff is called 13 weeks. 13 weeks in a 20-week period. That means you could lay off an employee, bring them back for certain weeks, and it'd still be considered a layoff until the full 20 weeks pass. So 13 weeks laid off in a 20-week period. A long layoff in Ontario is considered 35 weeks in a 52-week period. And there's a couple conditions to access that longer type of layoff. And that is the main way that employers do it is that they continue health benefits and any other benefits of employment while the employee is laid off. But for those employers who have already laid off employees, let's say they don't have a written contract and the layoff is coming up to 13 weeks, my advice is to get in touch with us or your other employment lawyer so that you can discuss the other solutions that you have in front of you. Because right now, as of today, which is we're in the middle of May, the provincial government has not updated the law, but I suspect they will. Each government across the country has done it in a few different ways, but for Ontario employers, it's yet to be seen. Either the province will extend the amount of a short layoff, or they may make another change. It's really currently unknown, but I have a very good feeling there are changes coming along the way. So layoffs, I understand from a lot of employers that they had no other choice. And like Alex said, like you said, I think the courts will recognize that when these cases go through the court system. And, there will be some recognition of the very difficult position that, every person and every business finds himself in during this period. So yeah, that's layoffs and terminations are a really important part of this whole, coming back from COVID. But on the other side of layoffs, of course, you have recalls. So let's say you've laid off an employee and now you're ready to bring them back. You're getting the green light from the government to say that you can open, and you've reviewed your books and you want to reopen. Rosalie, can you talk a little bit about what a proper recall looks like in Ontario?
Sure, I'd be happy to. So again, if you're not unionized and your workplace is not unionized and there's no sort of other rules regarding returns to work, the best way to recall is really, based on business needs and whatever you believe is best in terms of the bringing your business back to life. And that can sort of, we recommend that you establish some best practices to do this in the form of what you would be doing in a short term. So the short term kind of plan and then a longer term plan. And that sort of might include in the short term, hiring and recalling back your most essential workers first, and those who you really need at the bare bones to bring your workplace back to life. And then in terms of, a longer term plan, it would be maybe the highest performers, those who are full-time, and those who sort of can really bring everything back up to speed. And it's really important to note that you should not be calling back employees based on favoritism. And we did have an employer client call us up and ask us for some advice. And they said, look, we really enjoy working with this employee. They're wonderful. And we have a great relationship. And we know that the person would really want to get back to work. Can we just recall them back for that reason? Well, the answer is, it's not about who you personally get along with. It's if that person or the person who you're recalling really is helping you run the business and is doing their job, in the best way that you need to revamp at this time.
Yeah, or if their job duties, if they weren't available before, now their job duties, you have work for them to do, and they can do it, right?
Exactly.
Yeah.
Exactly. And the one thing we want to caution you about is that you don't want to appear that you are recalling only certain employees, because that might risk some sort of a human rights dispute or claim. For example, you don't want to only call back single employees or men, or those who don't have children, or those who are able-bodied. You want to make sure you're recalling, again, the emphasis on business needs. I think that's the most important. And you don't also want to assume that certain employees cannot return to work. For example, in smaller businesses, when you really have a close relationship with your employees, and you would know that they have children or they have, someone that they're looking after, you don't want to assume that they can't, be able to return to work on perhaps a part-time basis. You want to extend the offer and say, look, you can reach out to them and say, look, we have a need for a full-time employee. However, and we want you back and we want you in your position. However, we want to make sure and see that you're available during this time. And they may then be able to make some accommodations where they can have their spouse or a family member look after their children, for example. But you want to make sure that you are open and communicative with your employees, that you really do want them there. And it's sort of up to them to decide in what capacity at this point in time. We just want to be cautious with that. And again, to just have open lines of communication with your employee about what the possibilities are. So,
and Rosalie, does an employer have to send like a letter to their employee recalling them back? Is there some requirement that they're told in writing that they're coming back?
So not necessarily, no. Depending on, of course, the employment contract. If there's something specifically, there's nothing, required at law, but if there's something in the contract that says on recall, we have to do X, Y, and Z. So consult, of course, the employment agreement to be sure. But in terms of, an actual recall, if there's not that statement, we recommend you establish a best practice where maybe you would either give them a call. We've heard of some employers sending text messages because they have that cell phone and they have that relationship. But really it's notifying them in the best way possible. So probably via email. It doesn't have to be by mail. It doesn't have to be so formal. But we do recommend having a best practice. And in terms of sort of how the next steps look like after that, you'd again, to let them know that you're going to recall them, provide them with some notice. We think around maybe a week is reasonable. Whatever you can do so that they have time to rejig anything in their personal life that they need to do to come back. You let them know, and then they should be actually responding to you within a reasonable time and returning to work within a reasonable time. Mm-hmm. And again, as I mentioned earlier, you have to provide them with the same position upon their return to work, or if it's not available, you should get legal advice from us first, of course, or from any lawyer you want to consult. And you may be required to provide a similar position if their position no longer exists, or you may be able to terminate that employee. But again, you should seek legal advice before you jump to this next step. So next, I'd like to, discuss some other hot topics that clients have been bringing up to us. So really, we've been getting a lot of questions and a lot of concerns from employers. Our employees mentioned this to us. They've, come into contact with somebody with COVID, or their family member that they've come into contact with has also come into contact with someone with COVID, and they've really are very concerned about the health and safety of their workplace during this recall process. So I want to definitely talk about what the Employment Standards Act has done to help employers in this circumstance, which is establish a new Employment Standards Act leave of absence called the infectious disease or emergency leave. And what that is, briefly, is it's an unpaid job protected leave of absence where mostly the ESA focuses on an employee's right to take this leave. And they can do so, for example, if, the hottest topic coming up now is their children aren't able to go to summer camp, they don't have childcare, no daycare, they're looking after someone who's ill, various things like that. But the employer actually now has the power to put the employee on a leave if they are concerned that the employee may expose other employees to COVID-19 in the workplace. So that is, very, very like a
it
really
is unique.
hot topic. Yeah,
it is unique. And in my years of practicing, and I've spoken to other lawyers who maybe have practiced longer than I have, that what you've just said is absolutely brand new in employment law. So what it is, it's where an employer, and it's not based on discipline, it's not based on misconduct, it's not based on a snowstorm or a rainstorm. Those would be all good reasons to keep an employee out of the workplace. But this is if the employer has a concern that the employee may expose other individuals in the workplace to an infectious disease, including COVID. Yes. So how have you seen that work for the employers you've talked to, Rosalie?
So I guess, first of all, I would say, in terms of who I've spoken to and all of those things, definitely speak to a lawyer first if you're thinking about putting an employee on this kind of leave, because we don't have a lot of guidance. We've been, just like with this unprecedented situation, really flying by the seat of our pants, as are every single lawyer. We're trying to adapt and come up with solutions, and there's not a ton that the government and that the Ministry of Labor are giving with like substantive answers on how this should be done. So they gave a few small examples, and those have been applicable from what our clients have been calling us and asking us about. And really it's, in certain circumstances right now, they're very, very particular, but if your employee has traveled, that would be for sure an example if they're not planning on quarantining also, that would be an example where you could put them on the unpaid leave of absence. So that's really particular. But we want to make sure that we let you know that, of course, most of you listening are not doctors, right? There's no way that you can diagnose from seeing somebody or from any of those, reasons. Oh, someone sneezed. One sneeze or one cough does not mean the employee has coronavirus. And it's really important. It's really important that, you know this when you're listening. So in terms of what we believe might be reasonable, as I said, it's if someone's traveled outside of Canada, it could be that they've declared to you that they've come into close contact with somebody who has a diagnosis of COVID, or someone who, is directly in contact with someone with COVID.
And what have you heard? What are some of the examples that you've heard for that one? So you've talked about someone who traveled outside the country, understood. Someone who actually has the symptoms that you can see. But what does it mean if an employee declares they've come into close contact with someone who's tested positive? What does that mean?
So close contact is, actually defined by various things. So it's for sure someone who you've lived with. So if you've lived with someone who has COVID, if you are taking care of someone who has COVID, if you're conducting conversations with them without gloves and masks within, the 2-meter radius that's been required by the government for us to be physical distancing. So it's also if someone has sort of sneezed on you or coughed on you and you've been close enough to really feel that. So it's really all of those things. Living with someone, what we're understanding from the guidelines is they should be in self-quarantine. They should not be reporting to work. They should be also perhaps tested if possible. Now, the government's been saying a lot recently that they're going to be increasing testing, not just for people with symptoms. So I think this is where we'd hit home with this point, and where hopefully we may be able to, at some point, as Alex sort of said with the crystal ball, maybe request test results at some point so that when employees return, we have the all clear from them. But at this point, it's if you are living with somebody who has COVID-19, you should really be self-quarantining until you get the all clear from public health, and then you can indicate to your supervisor or HR that you've received the all clear. So even if you don't have symptoms and you've come into close contact, that's certainly a time where an employer can say, we believe that we have a concern that you would be risking the workplace and may expose employees to COVID-19.
And what's important there, I really want to emphasize it, Rosalie, because we're in May 2020 right now. There, regular rapid tests for this particular infectious disease are not readily available. And I think there's a recognition with that specific, very unique change to the law that an employer has a concern. There's nothing in the law that says it has to be documented. That they have a concern that the employee might expose other individuals to the infectious disease. Well, as of right now, it's not very easy for any person to be tested. As that changes and as circumstances change, the law is going to change. So I think it's important, to mention here, it's always, good to get an updated legal opinion, because what might happen in May 2020 might be completely different than what happens in November 2020. And, Alex mentioned a crystal ball is a very good point. We don't know exactly what the law will be like in November. We're going on, what the law is now with some, pretty significant changes since the middle of March. But, to emphasize that point, Rosalie, if you're an employer watching this and you have a concern that one of your employees may expose another individual in the workplace to COVID-19, you may be able to give that employee an unpaid leave of absence. But call us or call your employment lawyer before you do it, because I would say do it very carefully, right?
It's very sticky. Proceed with caution. We don't want to perhaps cause any potential discrimination issues, any human rights issues. We really don't want that. But at this point, the Ministry of Labor has left it quite open-ended. And so we're trying to work with interpreting it as best as we can right now.
Yeah. And it's a tricky balance for employers. On the one hand, right, they need to protect their larger workforce. On the other, they don't want to get it wrong. They don't want to send an employee who, like you said earlier, they're not doctors, or most of them aren't doctors.
The doctor employers are doctors. So if you're a doctor and you hire staff, then I think you may have a little bit more credentials to do that. But most employers aren't.
Not. That's right. But it's a tricky balance.
Yeah.
And it's important to try to get it right. And I could understand our clients' apprehension in approaching the task.
And something else I'll add before we move on is, if an employee is actually sick, you're beyond the point of a concern, because there are other, like Rosalie, you mentioned, there are other leaves of absences that employee can have. If they're sick, if they're under medical investigation, they are equally entitled to an unpaid job protected leave of absence. But a concern, how do you define concern? How does it have to be documented? Like I said, how many observations you have to collect before it turns into a concern, right? It's right now open to a lot of interpretation. And like you said, Alex, we don't want to keep employees out inappropriately. But if it's reasonable to exclude that employee, the employer as of the middle of March 2020, they have that ability to do that. And so we have to proceed very carefully. This is an employee, this is their livelihood, and we don't want to unnecessarily or unreasonably exclude them from the workplace. So yeah, those are
on the other hand, though, we've got to be careful to protect the rest of the workforce, right?
That's right.
How quickly this and how easily the transmission occurs with this COVID-19 virus.
And one of the main obligations, and I must have been saying this just like all of us have, one of the most important obligations an employer has right now is to take all reasonable precautions to protect their workers. And that is written very clearly in the law. So I think if an employer has a concern the Occupational Health and Safety Act, where that obligation comes from, an employer would be backed up. But what is reasonable is going to be different for every employer. What's reasonable for one employer might not be reasonable for another. But what I have found, to kind of switch gears and to talk about more of the health and safety side and reopening, what I have found is that there's still some very basic, precautions that I know many employers are taking, and I know a lot of, it's already being taken in grocery stores and other, public areas that are allowed to be open. And one of the first things that I'm telling employers about when they're considering reopening is continuing to allow employees to work from home. That is a reasonable precaution that an employer can take to protect their workers in the workplace. And so, more and more these days I hear of larger employers who are permitting employees to permanently work from home. So Twitter was one of them, recently Shopify. I think Facebook is moving that way. Now, Shopify is located here in Canada, but some of the other employers are located in other countries. But on a large scale and on a small scale, continuing to allow employees to work from home is a reasonable precaution that an employer can take. If it's not possible for those employees to work from home, there are many other reasonable precautions that an employer can take. So of course, I think it all starts with a policy, a written policy that clearly states, this is what we're going to do. And when I'm helping employers come up with a policy, I make sure to tell them this isn't written in stone. It's more of like a living tree, because as we further reopen and as the province, slowly allows more businesses and more people to go back into their daily regular lives, that policy is going to change. And the law is surely going to be changed to meet, the new demands of this new world that we're living in. The Occupational Health and Safety Act in Ontario, it was amended slightly, or sorry, the WSIB law was changed slightly, but the Occupational Health and Safety Act will surely be amended and updated soon. And so a COVID policy that we write now may have to be updated for June or November or next year. So, we're allowing employees to work from home and having a good COVID policy are some of the easier ways that employers can reopen their businesses. If an employer must have employees in the workplace, PPE is standard, and wearing masks. Currently we're not wearing any masks, but there are those in our office who are wearing masks around, and limiting amount of people in an elevator, for example, having one-way areas in the workplace, changing changing certain certain rooms like the lunchroom to limit the amount of people that are in the lunchroom are just some examples of what employers are doing. I also know some other employers are staggering the workforce that come into the office. And so this would be where employers could work from home, but they're also permitted to be in the workplace. You can have certain employees, maybe on certain days of the week, or maybe 1 week at a time, they're in the office and another week they're at home. And so that would be another reasonable precaution, depending on your workplace, the employer's workplace, that could be taken. What are some other different ways that you've heard of employers rejigging their workplace to meet their health and safety demands? Alex or Rosalie?
Alex, why don't you go first?
If you've heard of some, just some other examples.
If not, I can jump in.
Something simple as like if there's corridors, particularly with the cubicles, to avoid, in order to enforce social distancing, it's easy to kind of put signs everywhere and say 2 meters apart, and a lot of employers are doing that.
Yeah.
Signage everywhere. Remember to sanitize. This is how you wash your hands in the employee washroom. But it's also, we're human, and a lot of us have been working from home and are not used to coming back to the office. So the 2 meter apart in theory is easy. It's easy to remember, but in practice, it's also easy to forget. Mm-hmm. So a lot of signage in terms of arrows, right? This yep. particular corridor between these cubicles, this direction, one direction. So that way you avoid kind of cross traffic, which enhances the chance.
Like gatherings or meetings.
That's
yeah.
right. That's right. That too, right? Limiting, and I think that's important in terms of the gatherings in lunchrooms and things like that. For instance, I know one employer, they recently moved and got this huge lunchroom, and the idea was going to be a great collaborative space.
Yeah.
Well, thank goodness it's huge, but it looks silly, but it's safe. Everyone's sitting at these tables that are meant to sit 8 people at a time. Everyone's taking lunch at intervals, and
that's right. Yeah.
all have a
staggered
table
breaks. Yeah.
right.
Mhm.
Yeah. Yeah.
Things
So
like
in
that.
terms of what I've heard, which is also great strategies, we've heard of a few employers who are moving to meetings with 2 people who would usually be working in close proximity to actual large boardrooms instead, and projecting issues or problems that they need to solve on a whiteboard, and really one would stand in one corner and one would stand in the other, and they wouldn't shout because they'd be in the same room, but they'd be able to collaboratively discuss at the proper physical distancing limit, and being able to see, for example, I don't know, a computer screen projected, or having some ability to interact together in this room where they're not sitting right next to each other.
Yeah. Yeah. And then the other thing that I've heard, well, I'll say two other kind of larger examples. Number one, I think what goes with the policy is training. And, just because you give someone a mask, they may not fully understand, how it's used and how to best protect themselves. And, I've seen some people wear masks, but they don't cover their nose.
Mm-hmm.
And so that would be important to do. Or, if a mask says it's washable or reusable, well, what's the best way to do that? If there's a filter within the mask, what's the best way to do that? So training on not just the use of PPE, but all of the policies and all the precautions that the employer is taking, how can the employees, understand? Something that I've heard just kind of off the cuff is actually at-home ergonomics, and making sure that employees, when they're working from home, that they're still sitting on the proper chairs, and they're, not, kind of injuring themselves when they're working from home, because they're still, they are still your employees, but they're just working from a different location. So I think it would be a good reminder just to remind people how to sit properly in their chair and where to place their monitors and laptops. And the last thing I'll talk about is more of a Pandora's box, but I'll introduce it anyway. And that is temperature checks. Temperature checks, as of right now, there is nothing in the law that permits or prohibits an employer to do that specifically. Generally, human rights law before the pandemic would say that's a relatively intrusive method of understanding an employee's condition or potential disability. Okay, COVID has been recognized by the Human Rights Commission, not the tribunal, but the commission, which is more of a policy-based organization. COVID, they've recognized it as a disability. So we have to, tread very, very carefully. For any employer who's been asking me about, or asking us about temperature checks, the first thing I say is tread very, very carefully. There are, and I think if an employer does want to enact temperature checks, there should be a separate policy just simply discussing how it's going to be done, what data is going to be taken, how the data is stored, what will happen if there's a certain temperature that an employee receives. I'm advising employers to get a medical opinion, so they have a documentation of that to declare what type of temperature would be appropriate to be in a workplace or not. And who a temperature check applies to. It's not just simply employees. It would be any worker in a workplace. And not just that, it's really any person in a workplace, including any visitors as well. I think it would be reasonable, if you're going to temperature check employees, to temperature check every single person that comes into the workplace. There are kind of more issues, and I don't want to get too far into the weeds right now, but if you're watching this and you have questions about temperature checks, give us a call or send us an email, and I'd be happy to go over more of the nuances of what would likely be included in that policy. who is trained, who is authorized to take the test, what machine is being used to collect that information, and has that machine, thermometer, I guess, has it been calibrated appropriately? I kind of compare it to someone who is caught for speeding. And I have to admit, I have had a speeding ticket. It's not a criminal offense, it's a provincial offense. But one of the first things I do is you can request all of the information about the specific speedometer that was used to track how fast you were going. And if there's no proof that the person was trained on it or it was calibrated appropriately before it was used, there's a chance that a good lawyer can have the speeding ticket thrown out. And it would be the exact same way dealing with temperature checks. And the reason why that's so important is this is, again, another way to exclude a worker from the workplace and potentially taking away or not giving that employee wages. So whenever you're dealing with an employee and there's an ability for an employer, again, that has a concern that the employee may expose other individuals, it's very serious, and we tread very carefully when we're doing that. Did you guys want to comment on temperature checks and maybe some other advice that you would give an employer thinking about it?
I just want to add one point to that, which is, again, I'll pipe up again about the human rights concerns that I have with this. So you want to make sure that if you're going to go down this road of temperature checks, you are doing this maybe in a way that other employees are not going to be privy to this information. What are you going to do? We don't believe it's appropriate to have a clipboard and have everyone line up, upon their entry to work. Also, it's important to think about, if you're requiring them to do this, you're taking away some time from their work. Are you going to compensate them? Are you going to request that they come in early to do this? You have to come up with sort of a protocol. But we don't believe it's reasonable to have a long lineup, of many, many employees, and you say, okay, hi, Bob, for example, let me now check your temperature. And, the guy behind him, Phil, can really hear what you're saying. And you say, oh, Bob, your temperature is X, go home. And Phil's heard, and now Phil tells the whole line, and everyone now is, oh my God, maybe he has COVID. And there's a stigma associated with COVID-19 right now. And you want to make sure that if you're doing these things, you perhaps have the temperatures read in a separate room, or, write down the information in a way that is conspicuous, and that you're not going to have a giant list. And if Phil comes up next in line, he can easily glance over your shoulder and see, oh, well, Bob had a temperature of this, and I'm now going to tell everybody else. So you want to make sure that you're just protecting, number one, the privacy, because it is medical information of your employees, and you're also doing it in a way that's not going to be embarrassing or humiliating to anyone. It's also, too, how can you tell if someone's not running a little warm that day? Maybe they're stressed, maybe even the mere prospect of having their temperature taken causes their temperature to rise. I don't know. I'm not a doctor. I can't really say. Maybe that's a heart rate issue. I'm not sure. But I think it's more so the stigma is a huge piece. And if you're going to do this, have a separate room, and don't make employees feel badly, and try to, again, keep everything private.
Yeah, that's right. Yeah. No, like even sort of discrimination aspect, or the potential for discrimination of people who suffer from the disability in human rights parlance is a real one. But there's also protection of privacy considerations here. The Personal Health Information and Protection Act is alive and well during this COVID-19 era. So one needs to be careful with the information that you're collecting from the employees, not only for human rights, but also so that you're meeting your obligations under the Personal Health Information and Protection Act. That is a trickier balance, and there has been some indication that even though these standards are alive and well, that there is a recognition of the extenuating circumstances that COVID-19 poses. So for instance, I think it's acceptable to identify an employee who has tested positive for the benefit of the other employees, but it's not acceptable to disclose any other information about a employee's health status. If you're not within the health, as a custodian of that information, you have to safeguard it and keep it confidential.
Yeah.
So there are some tricky considerations there as well, which is again why when you're coming up with these policies, that it's best to have it reviewed with a lawyer, talk about what you have envisioned, and we can, or any lawyer who's competent in these areas can take a look at what your aim is and whether it makes sense, and try to minimize potential risk and liability.
Yeah, it is. And what I suspect, and Rosalie, you got your lights turned on again?
Yeah. Clearly I'm short and it's not really detecting me over here.
No, it's because we're doing a webinar. But what I would say, the last point on that would be, I suspect the government will introduce separate legislation regarding, or separate legislation, or amend the Occupational Health and Safety Act to provide some minimum standards when handling this, sensitive information. I wouldn't be surprised if there's a separate act, because like we said, it obviously it touches upon employment law, human rights law, privacy law. So of course, at least 3 of those, occupational health and safety, if I didn't say that already, a lot of different areas. And I think it really demands the government to say, okay, if you're going to check for temperatures, these are the minimum standards that you have to do. So as of right now, a strong policy is needed to avoid all these pitfalls that we're talking about, and we're happy to go into more detail about that. And the last thing I want to talk about kind of touches upon that as well is, and Rosalie, you mentioned human rights a few times, so you reminded me of another human rights issue. When you're bringing back employees, accommodation is still alive and well in the workplace. And so there are still, obligations that the employer has to all of their employees despite the pandemic. And that is the employer's obligation to reasonably accommodate their employees based on human rights grounds to the point of undue hardship. That has not changed. So the different areas, especially during the pandemic, that employers should be aware of to accommodate their employees: disability, family status, marital status, and there's another one that escapes me right now. What's the other one that I was thinking of? No, I think those are the main ones: disability and family status. So disability relates to, obviously, if someone is injured or ill related to COVID. Family status is any parent-child relationship that the employee is in. So it relates to their children, but it would also relate to their parents. Elder care is an important aspect of accommodation as well. If an employee needs some time off to assist a parent or assist their child for a genuine, like a medical issue, for example, the employer is obligated to accommodate. And the same thing goes for a spouse as well, of course. And there are, as Rosalie mentioned, some special leaves of absence that the employees can take that were just introduced. There are also some existing leaves of absence under the Employment Standards Act that employees are allowed to take related to family care, their own sick leave. Those all still exist. And so it's important that the employer is aware that their obligations to accommodate still exist. And the last obligation that I'll talk about here before I let my colleagues speak as well on this issue is the duty to inquire. I've talked to several employers who they're ready to recall an employee. They call them, they don't answer, they leave a voicemail. They call 2 days later and they don't hear back from them when normally they would have. And so the employer also has an obligation to, if there are enough red flags for an employer to think that something isn't really right, the employer has a duty to inquire with the employee. And so what I normally tell employers is, reach out to that employee however you can. If you need to send them a letter to let them know, we haven't heard from you in a while. We recalled you to work last week and you weren't we didn't hear from you. Are you okay? Is everything okay? Please get in touch with us. And instead of rushing right to, well, we didn't hear from the employee and so we want to terminate them, right? Like you said at the beginning, Alex, employers should be cautious when they're terminating employees, especially during this heightened time, this very unique time that we're in, dare I say unprecedented time. The employer still has obligations with regards to human rights and accommodation, and we're happy to discuss any of those issues. So, was there anything else that you wanted to talk about, Alex or Rosalie?
I just wanted to touch upon your points in accommodation, and it's not like a lot of and discrimination and human rights. I foresee that there's going to be a lot of well-meaning employers who are trying to be accommodating, but not in the human rights sense, right? They may say, oh, well, and it touches upon what Rosalie was saying too, in terms of recalls, right? Tim has 2 young children at home, school is still out, Bob's a single guy. I don't want to put the pressure on Tim to recall him, but Bob doesn't have any children, so makes more sense to recall Bob. I'm doing Tim a favor. So that, even though it's the intention behind it is well-meaning, have to do it carefully, because that is risk of being perceived as discriminating based on family status. So there's all kinds of it's a bit of a minefield out there, to be honest. A lot of overlapping considerations, and it's been challenging to keep up with all of the developments, but that's our job, to try to navigate through this new landscape. So we're happy to go along that journey with you guys if you need our services.
Thank you.
Rosalie, do you have any other concluding thoughts? Or
I guess just piggybacking off of that, really it's, make sure you reach out to employees, make sure you're, checking in with them and seeing how they are, because in small to medium workplaces, which is, mainly the kinds of employers we work with, there's a special relationship that happens in the workplace. And just because you happen to be, the top dog doesn't mean you can't reach out to as many employees as possible, or, assign maybe some of the other top tier, or I don't know what it's more senior employees to reach out to those below them and just say, look, we just want to check in and see how you're doing, and form that connection. And it's a difficult time. So it's not really just, you're running a business and these are your workers. It's, you have a relationship with these people and you want them to know that you're there. And I think the personal touch of maybe trying to set up a phone call or a video chat just to check in, maybe outside of work hours, if possible. If not, during a lunchtime or something like that, just to show that you're there, I think is really something that'll help employees with, any of their kinds of concerns, and may prevent potential lawsuits of if someone was laid off and there was no clause, as Alex was talking about. Maybe if you placate them and really, demonstrate to them that you care, there won't be a potential lawsuit. So that's something that we think could be great too.
Yeah.
Good communication avoids lawsuits. That's
right. That's right. Well, Rosalie, Alex, thank you for joining me, and for those watching, thank you for taking the time to listen to us. And if you'd like to reach out to us, we will get that information as part of this webinar, and you can reach us on our website, kmblaw.com. And yes, thank you very much for watching, and stay safe.
Stay safe, guys.
Bye. Thank you.